All right, we are fortunate enough to have Kelly Hawkes come by the office today. So we're gonna take the opportunity to ask Kelly a few questions. Kelly is with KH Paralegal, and she's an expert in all things LTB. So Kelly, first question. How do you begin an eviction process in Ontario? So what triggers the start of a legal eviction for a landlord?
Yeah, sure. There's all sorts of reasons that could start the process of eviction. The most common are non-payment of rent, non-payment of utilities, or maybe damage to a property. If you discover that's happening at your property, then you want to serve the appropriate notice. There's a period of time the tenant would have to rectify the issues on the notice. And then if they do not, then you want to make sure you take the next step to file the application to the Landlord-Tenant Board.
Okay, and what are the tenant's rights in this situation?
Well, the tenant has the right to appear at a hearing to state their side of what happened, and potentially, if there are reasons that the board feels they may be able to correct the behavior, then potentially they're able to preserve their tenancy.
Okay, and then just closing out the process, the hearing happens. What are kind of the steps and processes that happen after that, after the hearing?
After the hearing, you wait about 30 days to get the board to issue an order to you. And then the decision will be on that order, and all the directions of both parties will be there. It might be to pay the rent by a certain date. It might be that they won't repeat this behavior. And if they don't, or after that period of time expires, then you would be able to move ahead to file with the sheriff.
Okay, awesome. And then when you file with the sheriff, what does that look like? You're gonna make a phone call to the sheriff and then they're gonna come out?
No, it's documents. You file documents. It's a request form, and there's a fee to get the sheriff to go to your property. And it's filed through the small claims court, and then they'll notify you with a hearing, with an eviction date, and then they go out and give you back vacant possession.
Okay, look, if you're serious about real estate and ready to take control of your financial future, you can't miss this. On Saturday, October 5th, we're hosting the Your Life, Your Terms event, packed with real strategies to help you get ahead, whether it's your first or your 12th property. You're not just getting expert insights, you're tapping into a network of investors and doers who are out there making things happen. This is a community where deals get done and opportunities come to life. Grab your seat now before we reach max capacity. The link is in the description below. We're seeing with a lot of landlords and investment properties in duplexes, triplexes, and multi-units, noise complaints are becoming a bit of a problem. So what is considered a valid noise complaint and what is not?
Okay, a valid noise complaint would be something that is outside of regular living noises. If someone's, stomping across the floor or banging on the walls or playing music excessively, that's not normal noise.
Okay.
So those things could be considered interference with someone else's enjoyment of their tenancy.
Okay.
In that case, a landlord wants to start documenting. They want to start notifying the person they've received those complaints in the hopes that they'll adjust whatever it is they're doing in their unit. And if they don't, there is a notice that they would serve.
Okay.
That would address that type of behavior. Again, it will give them a period of time to adjust their behavior so that it's not affecting someone else. And then they would be able to go ahead and file an application if the tenant isn't willing to comply.
Okay, and what are the specific forms that they would proceed with in this situation?
For noise, that's an N5 notice.
An N5 notice, okay. And if it's determined that it is valid, what would be the following order or form to be?
Yeah, so if it's valid, then that would mean you have a successful application, and it could end in a conditional order where the tenant has to comply by order, and if they don't, then you could get termination of their tenancy, or it would terminate the tenancy because of the behavior.
Okay.
At that type of hearing, because there's multiple tenants, that they have to consider their rights and whether or not their rights will continue to be affected by this person's behavior, to consider terminating it.
Sure, okay. It feels like this situation is a pretty subjective one.
It is, it's case by case basis.
So your best recommendation to deal with that is just document everything that you possibly can, or what's?
Yeah, and I mean, the first step would be to report it to the tenant. I've received multiple reports that this is happening. Obviously, everyone has the right to enjoy their tenancy, and hopefully the behavior is corrected, but if not, that's the only avenue you would have.
If there's an investor, they have a single family home that as a rental, and it's currently tenanted. They want to be able to convert it into a duplex for, say cash flow reasons down the road. What's the correct process for those landlords to take?
Yeah, so it's definitely a process with a lot of hoops that you have to jump through. You definitely need to notify the tenant by way of a notice. That's the N13 notice. that's basically your filing an application to the board saying, I need to get this tenant out of the property in order to be able to do this. There's a compensation that you have to pay them. The notice itself has to include the scope of the work, and the work needs to require a permit. So obviously for that type of process, it would require a permit. The Ontario regulations also require you to notify the tenant how much work is going to be done, what's going to happen, how they're going to be affected through the process, if any of it can be done with the tenant still in the process. And yeah, it's really just about filing the application, making sure that you're notifying on your declaration, because that's required to be filed with an application, whether or not you've served that type of notice before to any property in the last 2 years. And the reason why they've required landlords to do that is because that N13 notice for renovations has really been in the news a lot. It's really been a lot of potentially people using the notice to have a tenant vacate and maybe not in good faith. And so they've really put some things in place that require a landlord to prove this is really what they're intending to do with the property.
Right. Okay. So say you go ahead with this, you do all the correct forms and notifications. The situation requires the tenant to relocate. So they relocate now, I guess, when all the renovations are complete. Since you're taking a larger property or a single family turning into duplex, now their I guess their rental that they had before is a bit of a different space in some situations. So how does that work? Do they get like first right to rent one of the properties, or kind of what does that process look like?
It's a very good question, because you have to look at it on a case-by-case basis. It depends whether or not that original tenancy is still going to be able to be fulfilled. Obviously, it's a smaller unit. So do they have access to the same place they had before? Technically, they do have first right of refusal to move back in once the renovations are completed. But at the end of the day, again, case by case, how much was the property changed? Is it possible to even have that tenancy continue? And that would have to be determined by an adjudicator at the board.
Right. Okay.
Yeah.
Amazing.
Yeah.
Thanks so much.
You're welcome.
Cool.